appeal for suspension of sentence.
After
Because it
15
was
June.
4 of Mekan
After 15 June.
and JST.
Please, Your Lordship,
Total-
I
total
already
guilt.
mentioned this.
Huh?
IA in criminal appeal, it was supposed to be listed on 26, but the cause list is
Give it to person. give it
Like
to
what?
person. Already we have fixed many.
No present. With regard to item number 5.
5.
I have been engaged, yesterday only, I cannot prepare. Can it be taken up on Friday next week?
Will not fix, this is I, you are pressing, will be pressing I.
Lordship,
Lots of I's have been fixed already.
this will be
I will-
covered by your lordship.
Court will give the dates, to Raisi, the pair of Mr. On the request of Mr. P.J. Soikin, as here was stepping for the appeal can appellant. Clear the case after we ready to fix by the office. Item Miss Avega, you have filed objection? Or not? Objection filed or not, Mr. Soikia?
Objection.
Okay,
Objection.
okay, Miss Avega, let us judicial public prosecutor, but the respondent state. is present.
May I please, Your Lordship?
Yes,
Lordship, this appeal has been filed against the judgment and conviction, and he has been convicted under section 302. There are altogether 3 accused felons.
and you are paying for all or?
I am appearing for all as a legal aid counsel,
Oh,
but in the cause list, only the name of one person has been shown.
Hard, Mr. U. Chaudhary. Learned legal aid counsel. For the accused appellants. And Miss A. Begum. Learned additional public prosecutor for the respondent state of Assam. This criminal appeals under section 415 within bracket 2, Bharat Company is preferred against a judgment and order dated 13/12/2024 passed by the Court of Learned Session Judge MIB in Sessions case number 106/2030. By the judgment and order dated 13/12/2024, How many were convicted?
Lordship, in total,
Oh.
there are other,
5
yes, Lordship. Five.
accused persons, including the present 3 accused appellants, have been convicted for the offenses under sections 147,
Lordship, total
One
6 were convicted.
huh?
6 at page number 81, paragraph number 67. Above all-
81.
Paragraph number 67, page number 81 of the appeal note. Debo Bormon, Rajiv Bormon, Topos Das, Ajit Bormon, Niren Bormon, and Dhananjay Kaur.
No, come to page paragraph 64.
64,
302,
302.
5 accused person. With a present again. Have been convicted for the offenses under sections 147, 140, 449, 302, 149, IPC. Full stop. Another accused person is found guilty for the offense under section and all the 5 accused persons, along with another accused, are found guilty. Then again, once this. No, we only COVID. No, headline, no, Ajit Burman, number 325, right?
Yes. 325. He is also one of the appellant in this case.
He is included among 5.
Yes, yes.
So it is 5.
No, Lordship.
Let
it
us
will
see
be
that,
six.
let us see that first item.
Six, Lordship, at page
Debo-
number
Debo.
81. In my appeal memo, page number 81, paragraph number 67. This is not a case which falls in the category of arrest of
Come
rare
to-
case.
1 minute. So, six accused persons, including the present three accused appellants, comma, are convicted for the offences under sections 147, 148, 449, 427, 302, 325, 149, comma, Indian Penal Code. So, code offense under section 302, stroke 149, comma, the present three accused appellants are sentenced to undergo imprisonment for life and to pay a fine of rupees 20,000 each, come out default stipulation. Full stop. For the often other offences, comma, different terms of punishments have been imposed. Full stop. We have gone through the contents of the memorandum of appeal. The appeal is admitted for hearing. The records of sessions case number 106/2020 in be called for. Issue notice returning to the courts as Miss Begum, the additional comment, here the accepted notice on behalf of the respondent state of Assam, in the province. The state has moved especially struck of the one and one extra.
There is an I.
Let the SCA come.
Lordship,
Any
and the
place?
other accused have already
Any
filed their
place,
appeal.
how many witnesses?
Lordship, in total, 8 witnesses. 18 witnesses.
18,
18,
it's
18.
paper book, it is not possible.
Lordship, and other
Let
accused,
the
have also,
SCR come.
other accused also filed their appeal.
Let them come.
Lordship.
Then we'll file up.
Hmm.
We'll receive the-
It is not possible for us to scan through 18
Lordship.
without the paper book.
Oblige.
Please, your lordships. Lordship, this is an appeal against the judgment and order dated and sentence dated 28/11.
You are, very good. Very good. Or Miss,
Dr. P. Agarwal.
hmm?
Dr. P. Agarwal.
P. Agar. Right. Council Board. Accused appellant and Miss A. Begum, are additional document prosecutor for the respondent statement. Also. This given level under section 415. Will you like to be an SSTU? Is direct, is preferred against the judgment and judgment. And order dated 28/11/2023 passed by the Court of Ladakh additional session judge FTC Karimganj in sessions case number 77/2008. Posted by the judgment and order dated 28/11/2003. Three accused persons, including the present accused appellant, have been convicted for offenses under sections 147, 302, 149 Indian Penal Code. And Muslim. The present accused appellant has been sentenced to under imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to undergo simple imprisonment for 2 months under section 302 stroke 149, IPC. For the offense under section 147, accused appellant has been sentenced to undergo simple imprisonment for 1 year. So we have gone through the context of the movement. It's same thing.
Lordship, there is an IA lordship. It's not on merits, lordship. The accused appellant is suffering from cancer. I've annexed the medical documents. He has already
Alright.
undergone operation twice,
So
lordship.
it's the counsel for the applicant appellant. And Miss and this is an application. I instant application under section 430. 14 brackets. 430 BNSS 2023 is preferred by the applicant appellant seeking suspension of the execution of the sentence passed against him and for his release on the applicant as the appellant has preferred a connected appeal. So instead of against the judgment and the issue notice. The judgment rules as well as what appeared accepted. Extra copy. The objection on behalf of the state is to be filed on or before the return.
A date could be fixed, lordship. My lord, he's not getting proper treatment.
File different application.
Where appeal lordship? There are two appellants, 3034.
Hard Mr. N. Mahajan. Direct counsel for the accused appellants. Offense,
3034, live.
Visual 34. And Ms. A. Begum, that it's additional public prosecutor for the respondent number 1 state. This criminal appeal under section 415 BNSS is directed against the judgments. An order dated 18/3/2025 passed by the Court of Language Additional Sessions Judge to be in Sessions case number 179 of 2024. By the judgment and order dated 18/3/2025, both the accused appellants have been convicted for the offenses. For the offense under section 302 IPC, related with section 34 IPC. And they have been sentenced to under rigorous imprisonment for life and to pay a fine of rupees 10,000 each, in equal the payment of fine, to undergo further rigorous imprisonment for 3 months each. We have gone to the Swenson. Admit. Records, case records. Sure of this. As well as so in appear accepted. Extra copy. The accused appellants will take steps for service of notice of the respondent who by registered postal daily will lead to.
There's a IM
Because the after here.
upon
Aye.
receipt, sir. upon receipt to LCR.
Aye.
Obliged, very good.
Four orders.
Mike has to be appointed.
Yes, to be appointed.
Okay. Offense, POCSO. Yeah. Okay, already appointed. By the previous order. By the previous order, already appointed.
The positives.
By the Miss B. Riala, Senior Counsel and Additional Public Prosecutor. For the respondent state of Assam. Is present. Close stop. By the previous order dated 22/7/2024, comma. Mr. Minmoy Doctor. The counsel from the panel of amicus curiae has already been appointed. Close stop. However, in the cause, comma, his name is not reflected. Close stop. The registry to reflect the name of Mr. Minmoy Doctor. Learned amicus curiae. In the petitioner side in the call list. Close stop. The records of POCSO case number 179/2022 case records are already received. The registry to prepare the paperwork accordingly. Full stop. Spera. As per the order dated 10/4/2025 of the Loajima Court, comma, service of notice sub under respondent number 2 as informant is complete. None has appeared for the respondent number 2 as informant till date. Let the case be listed again after 2 weeks for appearance of the respondent number 2 informant. Then we'll appoint. Receipt to take steps for preparation of the paper.
Six.
Yes, Your Lordship. दूसरी one, study through the telephone में, Yona the amicus in this matter was appointed, Senior A. Colita. Yona, he has informed me that he has not received the copy of the petition or the paper book from the registry.
Copy of the
Paper book from the registry.
paper book is not
Paper
there.
not
How can he
prepared.
receive?
Today his was supposed to appear,
Huh?
but none has
There
appeared.
is no paper book.
Oh,
It is consideration for the
Yes,
interim
for the-
application, not for hearing. When there is no paper book, how can you receive it? This is, I think, for consideration of the IA. Yes, madam. Objection
has
file.
been filed. Objection filed.
Objection file. That cannot be an excuse. Yes, madam.
Your Honor,
We'll
Yes. Yes.
first find out whether his contribution is necessary or not. Is Bhuya is there already?
But objection filed by Ms. S. Jahan, copy is available, not available. May I take a copy from this?
Objection fine. Okay, you go through it, thereafter we'll pick it up. After some time.
With due respect, actually what happened is that, they, as Jahan PPC has taken the petition copy and she is unwell, so she couldn't come to court today. My petition is with her. So out of,
SG Borua learned counsel for the
can it be on
applicant has
Monday? Monday or Tuesday?
paid for listing of this application after a week. Post of Ms. B. Huya, learned senior counsel and additional public prosecutor has submitted that Ms. L. Jahan, an additional public prosecutor, is to appear in this case. Mr. N. Kolita, learned counsel appearing on behalf of Mr. A. Kolita, learned amicus curiae for the respondent number 2, has submitted that Mr. Kolita has difficulty to appear today. Post of having taken note of the submissions of the learned counsel for the parties, this is the case on steps.
Lordship, it seems they have not received the papers of the paper book.
I will submit in that case.
Ms. Borua, learned counsel for the applicant appellant, shall furnish the copies of the memo of appeal
My lord.
and the interlocutory
Right.
application to Mr. Kolita, learned amicus curiae for the respondent number 2 within 2 days from today.
Must oblige me.
May I please have a listen?
Hmm.
Lordship, appeal was admitted, Lordship. Notice was issued.
Offense
Lordship.
Of course.
6, service,
Lordship, service complete, Lordship.
and we have to appoint one legal counsel first.
I'm not aware of whether steps have been taken on.
1 minute.
Who asked this, Mr.
Lozima Court, 2025.
Service is complete. Third, Mr. A. Google, legal aid counsel for the. You were for the IA or you were pressing the IA or what?
Lordship, his appeal was actually admitted, Lordship. Now,
Appeal admitted.
Lordship,
Are you pressing the IA?
Lordship.
Then,
We need to file an
for,
objection.
yes, you need to file the objection. Plus, some legal aid counsel is to be
Yes.
appointed. I will give. I would so it's not. But Mr. A. Gogoi, and legal aid counsel for the applicant appellant. And Ms. B. Bhuya, and senior counsel. And additional public prosecutor. Assisted by Ms.
Lordship,
Assisted by
Ardas.
Ardas. The counsel for the opposite party number 1, opposite party, that's respond number 1, state of some. As per order dated 28/3/2025 of the Lozima Court, service of notice upon the respondent number 2 is complete. So none has appeared. Respondent number 2, so informative. None has appeared. Order to represent the respondent number 2 as informant till date. Postmark. We deem it proper to appoint Ujjal Chaudhary, counsel from the panel of legal counsel, to represent the respondent number 2 as informant. Respondent opposite party as respondent number 2 informant. The case records of also case number 50/2024 are received. Oslo. The state. Now, the objections on behalf of the state. And there are political party just responding, but spoken for. Are to be filed. Within 3 weeks from today. Please the case. After course.
Deputy Principal.
File your objection, Mr. Chaudhary.
Right.
The name of Mr. King Chaudhary, let it plead legal counsel be reflected. Or for the husband number 2 be reflected in the husband side.
May it please all accept. Now, time in item number 8, my lord. This appeal, my lord, is directed against, my lord, judgment and order to the 28/11/2024 passed by the additional session judge Business Sirang, my lord. Wherein, my lord,
Yes.
there are 3 appellants, my lord. In item number 8, the appellant is Asmat Ali. And item number 9 and 10, my lord, are Mojid Ali and Zakir Hussain. Out of these 3 appellants, my lord, appellant Mojid Ali and Zakir Hussain were convicted.
Mojid Ali.
Mojid
Item
Ali,
number 9.
9 and 10, my lord.
And who
Mojid
is
Ali and
10?
Zakir
Who
Hussain.
is 10?
10 is Zakir Hussain.
Zakir.
They were convicted under 120B IPC and 302 IPC, my lord. 302 and 392
302
and 392
or 302 life.
imprisonment for life.
392?
10
Is
years.
it, is it
10.
robbery, dokaiti? What?
Yes, yes, yes.
What is robbery?
Yes,
Robbery.
yes, Robert.
Robbery. How
10
much?
years. And
10.
for,
10 years.
yes,
Hmm.
and for the appellant in item number 8, Asmat Ali,
120B.
120B only, madam.
Huh.
And he was sentenced to imprisonment for
Who?
7 years.
Who?
Asmat Ali,
Asmat Ali.
Asmat Ali,
7 years.
7 years.
So
He-
Asmat Ali is for only 120B.
120B. He was acquitted under 302, 392 and only convicted under 120B.
Hmm. Okay.
So it would be better, my lord, if item number 9 and 10 are started first because they encompass the entire evidence, my lord. My case is very limited.
9.
There were no objections. In both the cases.
Ready or not ready? Not ready. How many witnesses? 50. Yes,
Monday, no, shall go.
After some time,
not Monday. Tuesday, Wednesday is difficult. Either Thursday or
can
Wednesday,
it be
because
again?
Tuesday and Wednesday, there will be division bench.
They sent the certain spaces also there on Monday.
No, and
Can it be taken up?
Shifts, that bench is there, maybe.
Can it be taken up at 2, my lord, today?
Some possibility.
Friday, there.
Friday.
Next Friday.
Yes.
Okay, who are the council in item now, Mr.
Yes, that's my
8
lord. 8.
S. Das. Your name is not appearing.
Yes. In,
Okay,
Wow.
Mr. S. Das. Learned counsel for the appellant in 8. Mr. Ayu Chaudhary. Learned counsel for the appellant in 9. And Mr. An Uddin. Learned counsel for the appellant in 10. Are present. On the request of Ms. B. Mia. Learned senior counsel and additional property. Stated by Ms. M. Das. R. Das. Learned counsel for the respondent state of Assam. List the cases on Friday. Because listing on Tuesday or Wednesday, it will
Right.
not reach. And Thursday also there is some difficulty.
highly opposed.
I'll verify whether all the cases objection have been required.
Check. If 7 years is
Seven
only
is
that,
required.
Objection is not.
Okay, 7 years.
hard Mr. N.J. Dotto, learned counsel for the applicant, and Mr. R.R. Kosik, applicants, and Mr. R.R. Kosik, learned. Additional public prosecutor for the respondent state. Yes, sir, do you have any objection?
Well, the I is for continuation of delay 24 days. ma'am.
I'm cutting it short.
Yes, that's why when he's saying that stay when it's not.
Corrected by the. Sir, correction does not have any signature.
My lord, in fact, my lord, our calculation, it says 30 days.
There is
No,
correction,
office said, my lord, 24 days.
but there is no correction.
No
Your
correction.
signature. Whitener is there.
Why? I'll make the initial one.
Whitener is there. Inside incident. Here is the logo. Can you get? Inside one. Can I do signature there? Yes, there's no. You are Mr. Basundari. Make your signature here. This is an application under section 5 of the Limitation Act 1963, seeking condonation of delay of 24 days in preferring the connected criminal appeal. Goes down. The accompanying criminal appeal has been preferred by the applicants, by the two applicants herein as appellants against a judgment and order, against a judgment judgment and order dated 2/7/2024, passed by the Court of Learned Special Judge Concord Nogor at Pujai in special within bracket NDPS case number 114 within bracket H of 2022. By the judgments and order dated so and so, comma, both the applicants have been convicted for the offense under section 20 within bracket small b within bracket small Roman 2 within bracket capital C of the Narcotic Drugs and Psychotropic Substance Act 1985. And they have been sentenced to undergo rigorous imprisonment for 15 years and to pay a fine of rupees 1 lakh each, comma, in default of payment of fine, comma, to undergo simple imprisonment for another 6 months each. Full stop. We have gone through the statements and averments made in the instant application. Full stop. Considering the Mr. Kosik, additional public prosecutor has fairly submitted that as the period of delay is not much, comma, interest of justice will be better subserved, comma, considering the term of imprisonment, comma, if the accompanying criminal appeal is hard on merits. So stop. Having considered the fact that period of delay is only 24 days in filing the criminal appeal, accompanying criminal appeal, and applicants have been sentenced to undergo rigorous imprisonment of 15 years, comma, we deem it free and proper, comma, in the interest of justice, comma, that the accompanying criminal appeal, interest of justice will be better served if the accompanying criminal appeal is heard on merits by condoning the period of delay of 24 days in preferring the said appeal. So stop. Accordingly, comma, for instance, application is allowed the registry to register the accompanying criminal appeal and thereafter, comma, to place the appeal for admission.
I'm offline.
Item 12, on last occasion, the letter came, there are total accused persons, convicted persons. And registry was directed to verify whether other accused persons prepared the appeal. That has come, Lordship, no appeal is being prepared.
Hmm.
Lordship, may I pray this matter will be taken on Monday?
Okay. And learned amicus curiae for the appellate.
Yeah, he was there in the morning.
But materially is that he should be present when the matter is. Is not present today. Yes. Be here. Learned senior counsel and initial one. Senior the response has made it there for adjournment. List the as damage law. Consider request made by Ms. P. List the case after. Going to. 2 weeks. No, we cannot go on fixing simply many
Yes, yes.
others already fixed,
26.
you know, after 2 weeks. Let them prepare the cause list,
Yes.
raise 3.
Fine.
We are not preparing the cause list,
think 12 pilots.
It takes place.
for 2 weeks.
This is an bill against conviction. And the accused has been-
Appeal again.
On last occasion, my lord, Mr. Minal Sharma has been appointed as an amicus curiae, my lord. And this is appeal, my lord, against the order dated, my lord, 22/8/2019, my lord, for rigorous imprisonment.
Opens under
Opens under section 302, my lord.
302. How many appellants? 1. Case of direct evidence or indirect evidence?
My lord. Only, my lord, hearsay, my lord, only one eyewitness, my lord, PW2, my lord. But there is no, my lord, any eyewitness, my lord, because he has also stated, my lord, he have hearsay, my lord. So,
So according to you, it is a case of circumstantial evidence.
yes. Lordship,
Then why legal counsel for the husband number 2?
my
If
lord,
it is 302? For information?
in-
Okay. Okay. Okay.
Lordship, may I pray that this matter may kindly take it up after 1 week, my lord.
After 1 week. It's RS Theory, Learned Counsel. You are private counsel, right?
Yes, ma'am.
Learned Counsel for the appellant. Mr. R. Kosik. Learned. Additional public prosecutor for the husband number 1, state of Assam. And Mr. M. Sharma. Learned. Amicus curiae for the husband number 2, are present. Ms. Devi, Learned Counsel for the appellant, has made a prayer for accommodation. And to list, and for listing of the appeal after post. As the prayer of Ms. Devi is not seriously objected to by the learned council for the opponents. The prayer is allowed, it's been after regularly to this matters.
Let me inform Mr. Bakshi, he has already reached somebody, he will be coming.
Reach which place?
Lordship,
Reach which place?
nearby the court, he has said that, he has asked me to start the case. Lordship.
Start the case. You ready?
My lord,
You ready?
I have got my note, I have not patiently gone through it.
More than, I am ready, Lordship. I can start.
Ready? For spur number 2. It's not present. Stop. This, very, as for a request of this people. Additional.
Public.
To prove. To prove.
Yes, Supru. Case of sorry side, my lord. A case of sorry side, killing the wife. my lord.
Case of?
Sorry side, my lord. UX
Oh.
ROCID. My lord, case of
Killing sister. Or what?
the wife
Sukrurang wife.
and sister of the informant.
Case of eyewitness or circumstantial?
Circumstances and extrajudicial confession.
Ms. Begum, ready? Oh.
In the case of circumstantial evidence and extrajudicial confession.
Okay,
No
we'll,
eyewitnesses there.
we'll understand while going through the paperwork.
Yes, ma'am.
Take us chronologically.
Yes, madam. My lord, page 1, then my lord, we take the format of the FIR, my lord, page 1. My lord, column number 3, my lord, general diary reference entry number, Delhi PS GD entry number 368, 19/4/2014 at 5 PM. Then my lord, B, 3B, my lord, occurrence of offense day Friday 18/4/2014 at about 8 PM. Column C, my lord, information received on 19/4/2014 at 9 PM.
So this general diary entry is of any outpost or something else?
My lord, it of Delhi police station, my lord.
Delay.
Yes, it's otherwise an outpost only, my lord.
Hmm? Delay police station,
Page 73, my lord, is the GD entry, my lord.
page 73.
3, my lord.
Oh, it is Delay police station.
Yeah, it's a police station, my lord, I'm sorry.
Okay. Let us see the FIR.
My lord, FIR is at page 4, my lord.
Hmm.
Yeah, read me. Humble submission is that around 1 PM yesterday, on 18/4/2014, my brother-in-law Supru Urang, son of Athupudu Urang, resident of Upper Hatuka, Mangra Basti, PS Delhi, Kabri Long,
had an altercation with my younger sister, Malti Urang, over some domestic issues, whereupon he assaulted her with a stick. As a result of the assault, my younger sister died in her house at about 8 p.m. on that day itself. When the villagers came to know about it, they informed the police of the same at about 5 p.m. That is to say on 19/4/2014 and handed a
18/4 to Kuru, I don't know that. I think that was. I. At 8 p.m. Let me get up again. At 5 p.m. Okay.
and handed my brother-in-law's Sri Sukuru Urang over to the police. I therefore pray to you to take necessary action against the accused person upon investigating the matter and oblige. This is my humble prayer before you. And accordingly, my lord, until IPS case number 11 of 2014 under section 302 IPC was registered on 19/4/2014 at 9 p.m.
That was.
Page 6 is the order framing charge. The charges were framed only on 302.
Let us see the doctor.
Yes, ma'am.
First to the postmortem examination.
Yes, ma'am.
Let us have a look.
Page 26, ma'am.
Page,
PW 9.
postmortem examination.
Postmortem, madam, sorry. EM is at page 60.
Yeah. Date. Dispatch. Right.
Only my one aspect of
Picture of it. So that's. That's a very next. Okay, now doctor evidence.
now only one part, my lord, which remains out of the EM report is the time since that. My lord, you kindly come to page 26 PW 9.
26.
Yes, ma'am.
6.
On 24/2014, I was attached at Tifu Civil Hospital as medical and health officer. On that day, I conducted a post-mortem of deceased Malati Urang, brought by ASI Arun Gogoi and Dilip Urang in reference with Delhi PS case number 11/14 under section 302 IPC and found the followings: external appearance, a female dead body of about 32.
Same thing,
Yes, ma'am, same.
your cross is. If you are the only person in the house, then this cross I don't know what is the evidence. If this cross is made, then it is, might not go in your favor.
Yes, my lord. Because
If you are the only person, I don't know any evidence, I have not seen it for the first time.
only,
But this line
yes, my lord, this
could be a damaging one.
100% damaging.
You made one line cross-examination that appears to be a damaging one.
Should not have even cross-examined, my lord.
If your presence is found, because from the FIR it looks like that that prima facie, that everything was committed on 18th. The village people came to know on 19th. If this is the story, then this line, if there is nobody else in the house, you and the Regis, then might. This is one of the circumstances, maybe, could be. Let us see now. Informant.
Yes,
How did he say? Sunil Gaur. He is one, PW1,
PW1. He is the informant and brother of the deceased.
brother-in-law, brother of the deceased.
Deceased.
Okay.
He is a cultivator by profession, my lord. I am the informant.
He is a resident of what?
He is a resident of Hatukka, my lord.
Hatuka.
Yes.
Mangra Bostu. Okay. Oh, Upper Hatuka.
Yes.
Okay. Yes.
I am the informant of this case. I know the accused. Deceased is my sister, who was got married to the accused. The occurrence took place in the year 2014. On the day of occurrence, the brother of the accused informed me that the accused had killed the deceased after making a quarrel with her. Thereafter, I, along with the villagers, came to the house of the accused and found the dead body of the deceased lying on the ground with injuries. We also found accused in the campus of the house without talking with anybody. On being asked, accused informed me that he assaulted the deceased with lathi. On being led and shown by the accused, the lathi by which the deceased was assaulted was recovered from his house. After seizing the said lathi, police took it to police station. On the next day, I lodged a written HR to the police.
Yes.
Cross page 10, my lord.
Hmm.
I have not seen the incident with my own eyes. I have been informed by the brother of the accused. I have not seen anything except the dead body at the place of occurrence. He is not the Caesar witness to the seized lathi also.
Hmm. Yeah, I also.
PW2, my lord, Vipul Uran, page 11.
Like that. Oh. PW2.
Yes, my lord, Vipul Uran, a villager, my lord. And he's also a cultivator by profession, my lord. Married man.
I know the informant, accused, and also the deceased. The occurrence took place in the year 2014. At the time of occurrence, I was in Dimapur market at 11 a.m. The brother of the accused informed me that the deceased was murdered. Thereafter, I reached the house of the accused at 1 p.m. and found the dead body of the deceased lying inside the house on floor and accused in pensive mood. The people gathered there informed me that accused murdered the deceased. On being asked, accused informed me that he assaulted the deceased, but he also informed me that he could not say as to why he had assaulted the deceased. Thereafter, police came and sent the dead body of the deceased to Diffu Civil Hospital, and at that time, I accompanied the police. Page 12, my cross-examination. I have been informed by the brother of the accused regarding the incident. The brother of the accused informed me that probably the accused might have killed the deceased. I do not know whether there was any dispute between the accused and the deceased. Now, my lord, PW3, my lord, is Mangra Urang, my lord. He is the person who informed the police as per the GD entry, my lord. He is also a cultivator by profession, my lord. I know the informant, accused, and also I know the deceased. I don't remember the date of occurrence. On the day of occurrence, my villager informed me that accused murdered his wife. Coming to the house of the accused, I found the deceased lying on the ground with injuries. I also found the accused sitting in front of the door. On being asked, accused informed me that he killed the deceased with a lathi. Police took the said lathi to the police station. I also noticed the said lathi. Police came and went back with the accused. The police also sent the dead body of the deceased to civil hospital Diffu for postmortem. I accompanied the deceased up to civil hospital Diffu. Cross. My house is about 1 furlong away from the house of the deceased. I have been informed regarding the incident through the villagers. I saw the injury marks which might have been caused by lathi. After taking alcohol, the accused used to make shouting. Now, my lord, PW4, page 15, my lord. He is also a cultivator, my lord, same village, my lord. I know the informant and the accused. I knew the deceased. The accused is my elder brother. The incident took place some 4 years ago. I was not at home at the time of occurrence. The accused and I live in the same compound, but in separate houses. I went to work on the day of the occurrence. Later in the day, around 8 p.m., the accused called me to his house and said that the deceased had died. After that, I informed the villagers of the incident. Thereafter, I informed the police of the incident. The police arrived at the place of occurrence and seized one branch of a tree therefrom. I put my signatures in the Cecil list as a witness. The police arrested the accused and took him to the PS. Cross, madam. I found the deceased lying near a clay oven, traditional Indian chulha, madam, in the deceased house, but I do not know who killed him. So this was the brother, my lord, who inform the informant man about the occurrence man, as per PW1 man.
Yes.
PW5, my lord. Samuel Lagoon, cultivator by profession, my lord, from the same village, my lord. I know the informant and the accused. I knew the deceased. The incident took place in the year 2014. On the day of occurrence, I learned from the villagers that the accused has beaten his wife to death after picking a quarrel with her over some issues. On learning about the incident, I, along with some other villagers, went to the house of the accused, Sukru Urang. We saw deceased Malti Urang lying dead on the floor of a room of the accused person's house. At the time, the accused was also present. Then, as I asked the accused as to why he had killed the deceased, he told me that he did not know what had got into him. Then, showing a stick to us, the accused told us that he had killed the deceased with that stick. Thereafter, I informed the police of the incident. The police came and upon interrogating the accused, they took him to PS. The police took the dead body to DFU for post-mortem examination. Cross-melon. I did not see any cut on the dead body. Massimo, the secretary of the VDP secretary, it should have been the VDP secretary, went to the place of occurrence along with me. I did not see any blood stain on the stick shown by the accused. We reached the place of occurrence around 2 to 3 p.m. The distance between my house and that of the accused is about 3 kilometers. When I reached the place of occurrence, I saw 10-15 villagers present there. When I reached the place of occurrence, I saw Bandhena Urang, Sunil Gaur, Bandhana Urang, and others present there. It is not a fact that I have adduced false evidence in the court. PW6, Malu, Masi Mod, cultivator from the very same village, Malu. I know the informant and the accused. I knew the deceased. The incident took place in the year 2014. I was the secretary of VDP at that time of the occurrence. On the day of occurrence, some villagers came and informed me that accused has killed his wife after having a quarrel with her over some issue. After getting this news, I went to the place of occurrence along with PW5. Coming to the place of occurrence, we saw the deceased person's dead body lying inside a room of the house of the accused. After that, we saw the accused sitting in the room, and when we asked him as to why he had killed the deceased, he told us that he did not know what had got into him. Moreover, he showed a stick to us and said that was the stick with which he had killed the deceased. Thereafter, I informed the PS of the incident. After a short while, the police came to the place of occurrence and they interrogated the accused at the place of occurrence. When the accused showed the stick with which he had made the assault, the police seized the stick and I put my signature in the scissor list as a witness. Exhibit 1 is the scissor list. Exhibit 11 is my signature therein. Thereafter, the police sent the dead body to depot for postmortem examinations, cross-examination. When I reached the place of occurrence, I found some 15 people present there. I do not know the names of those people since my house is about 3 kilometers away from the place of occurrence. I do not remember the name of the persons who went to call me. I did not see blood stain on the stick which the police seized. I did not see blood stain on the place where the dead body was lying. The house of the accused was a Kacha one. I have known the accused and his deceased wife since before the incident. I did not witness any quarrel taking place between the accused and his wife. It is not a fact that accused did not say in our presence that he had killed his wife. It is not a fact that the accused showed us the stick which he had used in the incident. I have not seen the stick which was seized by the police in the court today. PW7, madam. Sri Dayal Jaja, cultivator from the same village, madam. I know the informant and the accused. I knew the deceased. The incident took place in the year 2014. Around 11 a.m. on the day of occurrence, I learned from the villagers that the accused has killed his wife, Malti Uran, and on receiving the news, I went to the place of occurrence. Going there, I found that the dead body was kept laid at the house of the deceased and that police personnel were also present there. Thereafter, when the police interrogated the accused, the latter, in presence of the police and me, confessed to have killed his wife. After that, when the police asked him as to with what object he had killed his wife, the accused showed a stick and informed the police that he had killed the deceased with that stick. The police seized that stick and I put my signature in the seizure list as a witness. Exhibit 1 is the seizure list and Exhibit 1-2 is my signature. Crossmill. When I reached the place of occurrence, I saw some 25 to 30 villagers there. Though the accused and I live in the same village, my house is about 1 kilometer away from the house of the accused. The police examined me. I did not tell the police that the accused has beaten the deceased to death with a stick because the accused has told police the same in presence of me. I have not seen the seized stick in the court today. It is not a fact that I have adduced false evidence in the court today.
Yes.
Yes, ma'am. Page 24, PW8. Bandhana Urang, Bhadro Urang. Cultivators, a villager. I know the informant and the accused. I knew the deceased.
I do not remember the date on which the incident took place. In the morning, on the day of occurrence, I went to Dimapur and returning from there, I learned in the village that someone had killed the deceased. Then I went to the house of the deceased. I saw the deceased lying in the deceased house. The people present there did not tell me as to who had killed the deceased. The accused was also present there at that time. When I reached the place of occurrence, I saw PW 7 present there. Yes, they are Jagan. PW 9 is the, my lord, doctor who has, my lord, who's conducted the postmortem examination of the deceased. PW 10 is the ION, Sri Arun Gogoi. On 19/4/2014, I was working as an ASI at Lahori Jan Police Patrolling Outpost under Dhilai Police Station. That day, the officer in charge of Dhilai PS called me away to Dhilai PS and told me that a person had been detained by the public. Since he had assaulted his wife at Upper Hatuka, Mangra Basti, and the officer in charge asked me to go to the place of occurrence. In this connection, the officer in charge made GD entry number 368 dated 19/4/2014, page 73. After that, the officer in charge, taking me along with him, proceeded to the place of occurrence. Thereafter, I was entrusted with the preliminary investigation. The public handed accused Sukuru Urang, who had been detained by them, over to us and I took him in my custody. Thereafter, I examined the village head and the people present there. They informed me that accused has killed his wife by assaulting her with a stick and that he had kept the dead body on the floor of the house. Then I prepared a sketch map of the place of occurrence. Exhibit 3 is the sketch map and Exhibit 3.1 is my signature therein. When I interrogated the accused at the place of occurrence itself, he confessed to have killed his wife. And he showed us the piece of a branch of tree that he had used in the incident. I seized that piece of branch of tree in presence of the public. Exhibit 1 is the sysalite and Exhibit 1.3 is my signature. As night fell, the inquest could not be held on the dead body that day. So I took the dead body and the accused to the PS. At 9 p.m. that day, informant Sunil Garg lost the Ajhar. On the following day, that is to say on 24/2019, I made a prayer to the magistrate posted at Pokajan to hold inquest on the dead body and the inquest was held on that day itself. That day, I arrested the accused at the PS itself and forwarded him to the Honorable Court. Thereafter, since I completed the preliminary investigation, I handed over the case diary of this case to the officer in charge of Dhilai PS on 21/5/2014. Finding that the investigation was complete, Mublik Parma, the officer in charge of Dhilai PS, filed the charge sheet on 30/5/2014. Exhibit 4 is the charge sheet and Exhibit 4.1 is the signature of Mublik Brahma, the officer in charge of Dhilai PS, which I am familiar with. Cross-examination. The name of the village headman of the village from which the disease hailed is Mangra Urang, the one who informed the police, my lord. The one who informed the police and the GD entry. noted in his name only, my lord. I did not make prayer before the honorable court to record the statement of accused under 164 CRPC. Many villagers, including Dayal, Masimod, Dilip Urang, and others were present when the accused confessed to have killed his wife. All the villagers said before me that the accused has killed the deceased. I did not send the seized branch of tree to FSL for examination. I recorded the statement of Badal Urang and Bipul Urang, whom I found at the place of occurrence. I did not see any blood stain on the floor where the disease was kept laid. During Dilip Urang, Dilip Urang stated while making statement under 164 that he had witnessed the accused assaulting the deceased to death. It is not a fact that I did not carry out the investigation properly. However, my lord, I could not find the 164 in the paper document.
When is PW? Leap,
My lord,
leave is PW.
Dilip. Dilip is PW4, my lord. Dilip Raghavan. Page 15, my lord. But he does not say the evidence also that he was taken to the court for recording his 164.
inactive role by PP. Dilip Urang trying to seal his brother. Dilip Urang did not tell lie, but he kept some missing links in his testimony.
Extrajudicial confession also.
Dilip did not tell lie, but Dilip told only 3 facts said, keeping 7 facts inside him. And PP played some role here. I'll not say positive or negative, but you can understand. Yes, because all you see the sketch map, all are jungle kind of thing. And all people are here, there, they have located themselves. There are wild elephants always. So out of fear, he did not go out that night. Only in the morning, he informed the villager. So he told the right things, but he kept something.
That is from a doctor.
Because in the FIR brother say correctly.
It's true.
Incident happened on 18.
And he was informed of that.
Villagers came on the next day,
19.
19.
And doctor have already appointed if the patient would have been
Huh,
immediately brought,
huh,
that line he
huh.
actually
And by Lathi.
Lathi
And both used to consume
consumed.
liquor heavily,
Heavily.
both of them. And this man, otherwise, in 161 story, I am not going into that. But otherwise, 200 rupees was kept with his wife. That day he asked like that 200 rupees. But the lady could not find where she kept or something had happened. Dilip was witness to it. There was quarrel
Quarrel.
for that 200. Then consumption, liquor and all these are there. Somebody said he used to shout after.
Yes, after listening. PW3.
He is habituated to that. Somebody said.
Somebody said that.
And thereafter, at night, yes, Dilip came and Dilip was shown the dead body.
The person who had.
Why he did not go? Because of fear of wild elephants. This is a jungle area. So if you go and the people are sparsely located, you have to go.
This case.
And in his statement, said himself. Then morning he went there. So he was telling the correct things,
But those were not brought in evidence.
keeping something, and then what he also did not say that all these children were out
Yes,
to Mama Bari on that day. He did not say.
it is not seen.
Okay.
And in the hearing of sentence, my lord, at which, my lord. the
I
accused
have seen
says
all
that-
are measures.
all are
I have seen all. The elder one is major.
elder one. Second also, my lord, 18 years.
Yes. What about his answer to question number 16?
No, he did not say anything.
No, question number 16,
Yes, ma'am.
page 37.
Yes, it is. Yes, I did not, but in my home, I was there. So 106 explanation is not there.
He was there.
He was there. So my lord, this 106 explanation should have been there. That is why I.
Now, he has a right to remain silent. But he said, one part, I was there. Second part, he owed an explanation. He could say it rightly, wrongly, or remain silent. He said, I did not. But if remaining in his house with his wife, then he owed an explanation. And if it is, she died, it was a homicidal death. Even if early medical treatment would have enabled his wife to survive, but keeping, because there is no question of blood, but fractures are there. Both hands, see. Apart from this area,
With the
Where is the
forearms-
doctor?
Forearm, there are lacerated wounds also.
see the
Page
doctor,
60
doctor,
Page 63, my lord.
PME,
Even in the postmortem also it has come, my lord.
PME. Lacerated injuries in both hands and forearms with this sign is fracture
Yes, my lord.
and dislocation of both shoulder
Both
joints.
soldiers also. Initially, she fell like this, my lord, and
He
thereafter
could have survived.
she could have, sir.
Whether this would be a circumstance which go in the favor of the accuser, because early medical treatment would have, you have
My lord, it
brought
will
in,
not, it will
you have
not,
brought in to doctor. Early medical treatment would have enabled the disease to survive. By keeping her in that injured condition with dislocation, shoulder joints, lacerated wound, left temporal region, both forearms fractured, and brother is obviously swayed by many factors. He was in real dilemma whether to implicate his elder brother or not. That is also a factor in his mind. He said truth, but half truth. That is a factor which is also required. But question is the circumstance he was in his house. That was not a defense anywhere. That I was not in the house. Or somebody else are also in the house. That is not a defense. And you admitted 313, I was there. And the lady was inside the house with this kind of injury. All these are rustic villagers. They only engage with other, say, officials like police or some administration through their village headmen. Until and unless village headmen contact, they on their own do not normally. I have gone to these places. So rustic. So this part is there, that you were there, your brother were there. He is saying half truth.
and in the judgment part,
He did not tell lie. He was taken to by you to inside the house, see my wife. No explanation there also. So remaining there and brother informed in the morning, he said, thereafter villagers came, all of them have seen them, the body and you. And you have said before them that lend some with and prosecution can only establish those things which are possible to be proved, possible to be established.
rest, my lord, in the judgment part also,
Hmm.
if my lord sees at the time of framing of the charge, my lord, or hearing on charge, my lord, he has admitted. But
Where
that
is
was
that
not
page?
reflected in the charge, my lord, in the charge
Where
column, my lord.
where is the page?
Page, my lord, page 42, my lord.
Hmm.
Paragraph 3, my lord. line from 3, my lord. On appearance of the accused person before the court of the then session judge cum deputy commissioner Kaveri English, charge was framed under 302 against the accused person by the state court after hearing the learned lawyers of both the side and person of the particular of charge was duly read over and explained to the accused person to which he pleaded guilty.
Hmm. 27/1/2015.
15.
So despite that, he rightly decided to proceed. Rightly. He decided to proceed.
He discarded the 229 provision.
Hmm. Madam, there is any 164 statement, this line? Huh? Case record. Just to satisfy our conscience. What Jimuk Marti Kitkan said
Really Quran.
that it used to be seen that innocent person should not be convicted at the same time. Guilty person should not be allowed to go scot-free. For me, it looks like this man is not very accustomed, not very expert in investigating this kind of cases. Read for everything, he is seeking instruction from OC. For every step, as told by my OC. He doesn't know anything, how to investigate. Does not look like. There is 164 statements. Who is Sunil Ura? The idea? Is he in the list of prosecution cases?
Charge sheet, I'm checking it. Charge sheet is at page 68, madam. No, my lord, she was not made a prosecution witness. madam.
One Sunil Gaur, he is the informant.
Sunil Gaur is the informant. madam. PW.
Yes, anything.
My lord, otherwise my submission would have been, my lord, that since the GD entry itself says that it
Hmm?
would have confined,
Bit louder, louder. Bit
my lord, the GD entry, my lord,
Huh.
at page 73, it
Page
says that I was confined by the villages, my lord. So, my lord, if I have made any confessions or any extrajudicial confession, my lord, that was under three portion, my lord. So, my lord, section 24 would be attracted, my lord.
Hmm?
Section 24 of the evidence act
Mm.
would be attracted, my lord.
Let us see section 24. What are the words used? In section 24.
Confession caused by inducement, threat, or promise when irrelevant in criminal proceedings. A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat, or promise having references to the charge against the accused person proceeding from a person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it would again, he would gain any advantage or avoid any evil of a temporal nature in reference to the proceeding against him.
So these villagers are persons in authority.
No, my lord.
Oh.
My lord, that would be, my lord,
You see
25,
this,
that would be
you
25, my
see
lord.
this also. If you see this, I don't know, this one is very important. First example, so Supreme Court. Extrajudicial confession made to village administration officer by accused is admissible. In our book, in the barrack. AIR 2006, Supreme Court 653. So village Gaugura, Mangra, if it is accused had confessed before him, it is admissible under section 324. Because he is not a person in authority. Because he would have to gain some advantage. So what is the inducement element? Threat element,
My lord, he was confined, my lord, he might.
confinement.
That comes.
Then
from-
the third one, promise. There was also no promise.
No promise.
Threat. He was beaten up,
That has not come in the
has
evidence.
not come in that.
That's come.
So that there was no inducement, no promise. Yes, threat could be somehow related with detainment. But none of them are persons in authority. And none could say that by making this confession, you would gain some advantage. And you have the witnesses say that prior to arrival of police, you have admitted.
Police was there. Some witnesses say that prior to their arrival, my lord, the police was there. Second part is that the weapon of the offense was not sent to FSL, my lord, and neither it was
Weapon not sent,
not sent and not produced in the court also, my lord.
not sent or produced. How far it is peddled?
Otherwise, my lord, the
There
witnesses,
is a law.
the law on that. Let me check.
Non-production.
Well, I am extremely sorry, my lord, I'm only having one copy of this only, my lord. The judgment was authored by my lord Justice Rishikesh Roy, my lord. It's a three-bench judgment, my lord, reported in 2020-10 SSC 733, my lord. Only the relevant paragraph I'm saying, my lord, I'm reading out, my lord. The alleged weapon of assault recovered on the basis of the statement of the accused could be a key evidence to support the prosecution. But unfortunately, the recovered articles were never linked to the crime. The police sent them to CHC for examination, and CHC doctor has stated that the injuries found on the body could have been caused by those weapons. However, in the cross-examination, doctor admitted that the bloodstain or other marks on the exhibit could not be seen. The weapons were reportedly sent for chemical examination, although the trial court had referred to the report of the chemical analysis to conclude the presence of blood on the exhibit. But the purported chemical analysis report is not found available. However, my lord, this will not come because it was never sent to FSL.
That part, plus the lady did not sustain any injury as a result of which blood was oozing. The nature of injuries were different.
Quite different because, my lord. Correct, my lord.
No blood,
No blood. my lord.
no incision. Left temporal region and all were fractured.
Fracture, my lord, internal bleeding was there.
Dislocation. Outside, nobody could see.
Nobody said any blood was
Ah,
seen in the.
Nobody could see injury.
That part, correct.
These witnesses said. They are truthful to that extent. Nobody had exaggerated.
That's correct, my lord. Because they say that we have not seen the blood in the weapon also, we have not seen the blood on the floor also, where the body was lying.
They are truthful.
They are truthfully.
And that sort of a person, at least though they were post-occurrence witness, but so far as they have seen the body and the surroundings. So there was no blood.
No.
And that person is consistent with the medical evidence. Dislocation, fracture, temporal region, all this. So though they were rustic, That is the advantage that they were truthful.
Last submission, my lord.
We are receptive to all submissions.
My lord,
Just we are
If-
finding out.
question number 16, which your lordship has shown at page 37, my lord. The answer to my humble understanding, my lord. PW8, my lord, I'm reading the questions and thereafter, my lord, I'm trying to place my argument on the answer, my lord. PW8C, Bandhana Urang, Bhadra Urang has stated that nobody told him who had killed the disease. At that time, you were also present there. Have you anything to say in this regard? So, my lord, the question is that by the time when Vandhana Urang saw him, he was there at the house. So he has said, yes, I did not kill, but being my home, I was there. So he is referring to the time when Vandana Urang has seen him.
Good.
So, my lord, the 106 explanation, even it could have come in this case, my lord. If that is read in the submissions I have made, my lord, then this 106 part will not come out. That apart, my lord, at the hearing of sentence, my lord, the accused has said that altogether he is in 5 children's, my lord. So none of the, well, the major children's, my lord, the prosecution did not take any endeavor to bring on those children's, my lord, at least to bring some evidence for the prosecution. Because the evidence has not been laid that the children were not there at home also, my lord. Even if they were out, my lord, it is not the case of the prosecution there.
Yes,
were
you
not
should
at
have
home.
also proved it is not a prosecution. Prosecution knows why. Just delete, did not say that it's only you who had taken him. It should have been a defense strategy. I have my children there. Then it would be preponderance of probabilities.
That, my lord, the defense lawyer who are legal aid to the case, my lord, he did not
I
take
see.
any endeavor to bring on those parties.
On Mr. Arnav Datta.
I know him personally. I know him personally.
Effective investigation can be a plea.
Yes, ma'am.
Huh?
Yes, ma'am.
I have seen somewhere I haven't looked into it. This immediate medical attention would have survived, would have enabled the disease to survive. I have seen somewhere. Some law has been laid down. Whether in favor or accused, I have seen just the headline, head note. Yes, madam. We may have change, we will put it on Monday. That I have to see. I have the head note. I have not read the detailed judgment. I have marked it somewhere. I'll get it. I have to find out. It should not be moral conviction. It should be legal conviction, right? We have to change it over. I mean, please. Tell me, what are the lacunas? How it is to be interpreted? He said, weapon was not sent. Weapon of assault, alleged, right? Some witness say that he had sold somebody T branch, somebody Lathi. Where is the seizure list?
Season list, my lord, it has page, my lord, 58.
58. Branch of tree,
Yes, branch of.
3 feet. Yeah, 3 feet. Great. That's much. Oh, it is possible, left temporal region possible. This location is also possible. Okay, and this one. It was not, did not opined by the autopsy doctor how this kind of injuries can be caused. One part. Few witnesses say that police arrived at the place of occurrence, seized one branch of tree, right? PW 4, Lilipurang.
Brother.
Then PW 3. On being asked, accused informed me that he killed the deceased with a lathi. PW 5.
Like why he had killed the deceased. He told me that he did not know what had run into him. And showing us a stick to us. The accused told us that he had killed the deceased with that stick.
When the PW 6 Masi Mount,
Page number 20, doctor. So, 19 starts with the relevant question is. He told us, 6 line, he told us that he did not know what had got into him. Moreover, he showed a stick to us and said that was a stick which he had killed the deceased.
thereafter I informed the PS, police station. So there are two parts. One is pre-arrival of police, another post-arrival of police. Record it. We use record it. It's recorded. See. Here's the admission. Recording means writing.
state lordship that after taking alcohol, the accused used to make shouting, PW3.
These witnesses had no animosity, apparently.
That lordship.
No animosity with the accused
Accused.
to implicate him. And they are not interested witnesses.
More interested.
A few of them are not related witnesses also,
They are only related.
villagers.
They have nothing to do with them. And in this regard, lordship, I would like to give one judgment, lordship. 2012 6 SCC 403 Sahadevan versus State of Tamil Nadu. Para 11 lordship.
Well, the recent Supreme Court judgment is taken care of. This Sahadevan has been taken in the recent judgment by my Lord Justice S. Ukha and my Lord Justice Ujjal Kumar. Reported of 4th of February, para 19, my Lord.
Para 19.
19.3 also.
Oh, para 19. Yes.
Referring to para 20 for a moment, my Lord. Of this judgment only, my Lord. One part, my Lord, why I took this judgment was, my Lord. Some have said that the accused has replied that I do not know what happened, what went inside me. So, my Lord, Para 20 says that having surveyed the principles governing the acceptability and evidently value of an extension, we may now advert to such confession made by the accused below PW 1, 3, 4, and 6. It is on record that the PW 3 in his cross-examination was quite categorical in deposing that he found the accused to be in a confused state of mind. My lord, two of the witnesses in my case also have stated that the accused has stated that I don't know what went inside my mind.
That is all right, Lordship, but you would have taken his wife immediately after some time to the doctor, Lordship. Was in a different state of mind, but he have informed his brother. The contact is clear.
Subject to correction and with respect. This paragraph 22,
Yes, paragraph 22.
I have read.
Your lordship has already passed similar, my lord, in one of the cases disposed of by your lordship, Vishnu Udangia, my lord. Lordship has taken the very same view which is there in para 22, my lord. As far as the 161 and 162 part is concerned, my lord, that aspect, my lord.
Paragraph 22, I have read now, paragraph 11. How PW 3 was examined and cross-examined. But his previous statement was not brought on record. And contradiction was not proved or omission was not proved by putting the previous statement to him and marked it, by marking it. But this conclusion at paragraph 22 with respect, greatest of respect, that omission and contradiction without bringing it on record. Because testimony before the court has the ultimate sanctity. And to disprove it or to bring contradiction or omission, you have to bring the previous statement on record, put him there, then to the IO. Could not find on a cursory glance in this judgment.
My lord, this part I have learned from your lordship, and that is why nowadays when I'm doing a trial, my lord, I'm very cautious about this part of the aspect, my lord. Whatever is there in the 161, at least that has to be brought while doing the cross-examination. Otherwise, I'll fail my case, my lord, if I don't do that, my lord.
Because para 22 does not look like that. You cannot test the credibility of a witness by comparing his testimony before the court and going into the
Yes, yes, too.
161, when it is not brought on record by marking it as an exhibit, that part. This I have to read on a cursory glance. I have read paragraph 11, how PW3 was examined. Paragraph, which paragraph you have shown?
22, my lord.
No, not 22.
19.
That is okay. That is okay. But 22, I have some doubts. I have some doubts. This is going in a different way. If this is the thing, then right now it's PW 4 statement recorded under 164.
Lordship can convict the accused and
Oh.
close out the case, my lord.
There is no trouble for me.
Yes, lordship, this is what, my lord, I'm just skipping out this para 22 from.
There will be no
But
trouble.
lordship-
Every case I'll see the case that yes, this is true. Subject to correction, I have just had a cursory glance. There are other points, but this part I am not very much agreeable to it. Unless it is based on the proving that part of the 161 thing. Otherwise, you cannot draw a conclusion. Alauddin may be in a different context. Testimony cannot be tested or credibility cannot be tested by comparing readily 164 state. Look into it. We'll read. Put it on Monday.
Yes.
By many, because the effective
Yes,
investigation
my
is
lord.
also
I
there.
also like to, my lord.
No, if
something-
you want to give, so that we can read. Sitting here, we cannot read. Yes.
Which one, my lord?
Anyone you want to?
No, no, not
Oh,
today. my
today?
lord, Monday, Monday.
Few points only, that extrajudicial confession, right?
Yes, my lord.
Sahadevon.
Now,
Sahadevon.
Sahadevan.
You want to-
Sahadevan, para
there were 11 and 16. Look.
in my judgment which I placed, my lord,
Sahadevon has been referred.
yes,
Based on Sahadevon only,
based on Sahadevan.
you want to show paragraph
11, 16.
11. Sixteen. Now that has been quoted in
Not cheap.
In this
Yeah.
judgment also,
Not cheap.
in this judgment.
It is
also.
quoted. In 2011, criminal to 38, 2004 apex period. 2003, 8, SCC 180.
one is immediate medical attention.
Not cheap.
Second, PW4. He was saying truth,
You are saying,
but
How?
How? If I can go on readily like this,
not cheap.
paragraph 22, everything is, chain is complete. I might not be able to go there. Extrajudicial confession about the weapon of assault. Then The accused kept detained, so section 24 would be applicable or not? Section 24, weapon not sent nor produced. Defective investigation. And whether accused owed an explanation. Owed an explanation. Whether in these facts, 106 would come in or not.
Except in 5 children will not present.
Whether 106 comes in or not. At 2 o'clock. Monday.
One day. Today.
Hmm?
Today is second.
No, we have to think it over. It cannot be immoral.
Lots of them.
Hard mess, 8 July. Let it Amicus security for the happened. MS. Aiming on the additional purpose of the progress. Is the case Monday. For further hearing.
Deeply.
Else,